the number of entrepreneurs that we work with or that come in our doors that do not have basic estate plans put in place. And this hits me a lot more now as a young father. I would say that my estate plan never, I mean, I get it. If I wasn't a father, I never really cared that much, but now being a dad, it's super important. And as you know, there's some juicy celebrity. That was a weird, that's a tough word for me right there. A few celebrity
you just went
stories.
through all this stuff about F reorgs and you couldn't say that word.
You know, we all have
shocking.
our challenges.
Yeah.
So what I want to do is just go.
It's like you can't tie your shoes, but you can do, you know, calculus or something.
Let's go through each of these documents one by one in terms of the importance of them. And then I'm going to pull out a few real life high profile case studies that illustrate what happens and how quickly this can go wrong. So first document, Jim, I want you to break down is the last will and testament.
So the last will and testament really is about telling the probate court how you want to distribute your assets. So probably for most of you, you're going to need something called a revocable living trust that we're going to talk about next. And your will would be a pour over will. So if you forget to put something into the trust, that the will would tell the probate court, hey, I forgot to do that. Would you please pour that into my trust? In addition, though, it does have things like who's going to take care of your kids. And I was wondering, are Mimi and I anywhere on that list where we have to take care of your kids?
You are on the depth chart, but not in the top 3 positions.
Okay, good.
So just not in writing yet.
Good. I didn't mean good. I meant, oh, darn. I wish we could take care. We're too old. You want our kids to, you don't want me to be in a walker trying to help your kid throw a baseball or something. So that is an important part of the last will and testament is, who's going to take care of your kids and stuff like that. You'll name either an executor or a personal representative, depending on what state. If you don't even have a will, then you go through intestate probate, which is intestate is a Latin word for really, really bad probate. You don't want to do that. It's the state laws that will tell how your money is going to be distributed, who's going to get it, how it's going to be managed, and all those kinds of things. So you have to have a will, but generally it's going to be a pour over will.
Yep. All right. Well said. And I think the biggest thing is if you don't have this, the state laws are going to dictate what happens to your money. Everything is going to be public because probate is a public process and probate is expensive. So those are the sticks, so to say, of what happens if you don't have a last will and testament. And as a father, like I said, the biggest decision, which was interesting, was actually guardians. That was, to me, a lot bigger decision than the trustee.
Definitely.
Because the trustee, to me, is someone who handles the money, and I trust making good financial decisions. But guardians is the one who's responsible for raising your kids.
Right.
And that, to me, was the biggest decision, even more so than trustee. And before I had children, I never really thought of it that way. I was always under the impression that the trustee is the biggest decision you make. And sometimes it's the same people. But in my situation, I actually wanted to bifurcate the roles and responsibilities just to mitigate the chance of any type of abuse. And so I wanted to isolate who had control of the pocket, the purse, so to speak, which would be the trustee, separate from the guardian who's making the decision. So that way the guardian can go to the trustee asking for money for certain things for the kids if Lane and I are no longer here. But I didn't want there to be that self-fulfilling, that do loop that they can just be like, oh, I think I need that new Cadillac and the boys need that for a smoother ride. So here's 150 grand I'm going to pull out of the trust for them kind of a thing.
Most definitely. Yep. It's important.
Let's go into the revocable living trust. So you did a great job. I think you just need to keep the momentum.
Sure.
Why do entrepreneurs need a rev trust?
A revocable living trust, and I'll just dispel a rumor or a myth, and that is a lot of entrepreneurs think that a revocable living trust has asset protection. It does not have asset protection until somebody dies. After someone dies, there can be asset protection, but while you're alive, your revocable living trust has no asset protection. There's other things you have to do for that. The main things that revocable living trusts do is they allow you to avoid probate. So they allow for private transfer of all your wealth, so you don't have to have it public through the probate process. Quick, easy, private. In addition, it allows you to, a revocable living trust can hold the assets beyond your death. If you transfer your wealth through a will, it just gets distributed. So if your kid's 21 years old, the money is just going to get handed out to your kids. With a revocable living trust, you can put on rules and stipulations and people to manage the money, and it can be doled out over years. So it allows kind of to be you managing the money beyond the grave, so to speak. That's a really important part of a living trust. It also can preserve your $15 million now exemption. So if you're a married couple, if you have a trust, you can protect that part of the distribution by using a trust that you lose if you don't have the trust. What else would you add to revocable living trust?
I'd say the funding of the trust,
Oh,
because
right.
far too often we see entrepreneurs, hey, do you have a trust? Yeah. And then they do have a trust. They have the document, they signed it, they notarized it. And then you look up the title to their real estate, the title to their investment accounts, the title to the private equity, the crypto, and it's all in their personal name. So they have the trust on a piece of paper, but if the trust doesn't own anything, then it can't govern anything. So it's not just about creating these documents, but then funding the trust, which just means retitling the appropriate assets in the name of the trust. So the trust owns those assets, not you as an individual.
Yeah, that's really smart. And we see that mistake all the time. In addition to that, you name trustees, and those would be the people who would manage the assets, follow the rules, decide when to give money to your kids, for example. And you want to think in threes. This person, if this person is unwilling or unable, then this. If this person is unwilling and unable, then the third person. Think in threes. You want to at least have threes. People get old, people die, people maybe in a life situation where they can't do it and they can say, I'm not going to do it. And then you go to the next person. So trustee is a critical piece. And then another thing that I like put into a lot of trust is a trust protector. And a trust protector really doesn't have anything to do unless there's a problem with the trustees and the beneficiaries. And the trust protector usually has only two jobs. One would be change of situs, like if there's a reason to move the trust to a different jurisdiction. And two, which is the most important one, is replacing trustees. So the beneficiary could come to the trust protector and say, hey, this trustee is not giving me money that I need. Then the trust protector goes in, looks at the trust, looks at the situation, can say, beneficiary, no, you're wrong, trustee's doing a good job, or replace the trustee. So I like that position in most revocable living trusts.
Yep, I love it. All right, next document, power of attorney, specifically the financial power of attorney. So I'll take this one. This really governs all of the assets and your finances that are not owned by your trust if you're incapacitated. So the easiest way to describe this is, well, if the trust owns real estate or any type of asset, your business, let's say, if you're incapacitated, then the successor trustee gets to step into the shoes of all the assets that are owned by that trust, of which your business could be one of them. Now, if that's the case, make sure you have qualified subchapter S stock trust language built in. If you have an S corp and it's owned by your trust, so just check the docs there. Whereas the financial power of attorney is anything that's not owned by your trust. Well, hey, I'm incapacitated. Who can actually, handle my affairs while I'm incapacitated? That's where the financial power of attorney comes into play. And I think that the decision, or one of the big decisions here, is do I want it to be durable or do I want it to be springing? And what that means is durable, whether or not I'm incapacitated, it's going to be alive or there at all times. And this is beneficial if you're, for example, in Europe all the time and you need someone to go close a real estate deal for you and sign and notarize docs. Well, your power of attorney can do that in person. The flip side is springing, and springing is going to be based off of a definition. And so then it's important to understand, well, what is the definition? And normally it's two independent doctors certifying that you're incapacitated, which means that that document is null and isn't valid until that threshold is met, which is generally two independent doctors saying you're incapacitated. Then that power of attorney comes into full force. So that's usually a decision that clients have to make. Do I want this power of attorney to be kind of on file and live at all times? You only would want to do that if you really, really trust, the people who have your power of attorney, probably your spouse and maybe nobody else. Whereas the flip side, the springing is, to me, a little bit more logical that if I'm incapacitated, then this happens.
Yeah, definitely with spouses, we usually see a standing or a durable power of attorney rather than the springing. And if it's other family members, often we see the springing for those reasons. And do you have certain doctors you want involved? Like you can participate in how you set up the language in this document to what is the triggering event, who has to decide whether the financial power of attorney becomes valid if it springs into effect. And then some other things like gifting. Does the agent have the ability to gift to him or herself? And there might be situations where your child, when you're older and your adult children, maybe you want them to be able to gift to themselves for tax planning or estate planning purposes. Maybe you don't, because that introduces the opportunity for abuse. So is there the ability to gift to others or to the children or anything like that under the financial power of attorney?
Yep. All right. Next one, healthcare power of attorney. So Jim, break that one down for us.
Yeah, so this is really designated who's going to make medical decisions for you. And with the HIPAA laws that went into place a couple decades ago, there's some teeth in these rules. So even if someone, let's say two people are living together and they show up at a hospital because one got in a car accident, you don't have a healthcare power of attorney. You have not designated that person to make decisions for you in this medical situation. Even with spouses, it can be challenging because hospitals are afraid of getting sued. So not only does it designate the person, and again, think in threes, this person, then that. In addition, you want to know what's the language in there. what guidance are you giving to that person? Because often, Mimi and I have been married for 33 years. How often have we had conversations about like, okay, you're in the hospital in this situation. What do you want as far as your medical care? How do you want your pain management to be handled? Those kinds of things. We don't really talk about that. So all of a sudden the spouse is in there. There's no guidance for the spouse to make those decisions. So the healthcare power of attorney is critically important, gives you the power to make the decisions alongside of the doctors, and also gives guidance. So this should be something that you look at and you're thoughtful about, before you put into effect. And usually when you go into the hospital or to see a doctor or you have a surgery, they're going to ask you, do you have a power of attorney? And often it's good to give them a copy of it in case something goes wrong, for whatever the reason that you're there for.
Yep. All right. Last document, living will, advanced life directive. This really is just all about documenting your end of life wishes. This is organ donation. This is, do you want anything to be preserved? Some people want their brain to be preserved in a cryo chamber, pull the plug, all of that type of stuff is spelled out here. And this is where the entrepreneur, you are going to have to make some decisions and make some initial next to some of these different things. And then that way, if you're incapacitated, it's very clear what some of your wishes are.
Yeah. I mean, that allows you to tell a doctor or whoever's taking care of you, hey, I want to go. If I'm in this condition, I don't want to be kept alive. And often if you don't have that type of a document, again, you take a spouse, for the spouse to have to make that decision when the spouse doesn't really know what you want would be just a really gut-wrenching decision to make for somebody else. But having it in writing that you've said ahead of time, hey, I don't want to live in this condition. And I'm going to give a little shout out for organ donation. Mimi and I are organ donors. And I see so few people do that. And yet, here's the arguments I hear. Oh, I'm afraid they're going to harvest my organs before I'm dead. I don't think so in this world of lawsuits and everything else. And it saves so many lives if something happens to someone. And if you're not using them anymore, right? If you have any good organs, why not help someone else have an extension to their life or quality of life that they didn't have? Anyway, there's my pitch. It's a personal decision, but I wish more people were organ donors.
You'll be happy to know I am an organ donor. It's on my driver's license.
I like it.
And it's in my advanced.
The older I get, the less I think my organs are that exciting, for people. But it's that diminishing returns.
You need that younger blood, right?
Yes.
Peter Thiel.
People would rather have your liver than my liver.
That is true.
You know.
All right, let's go. But I'm closer to college, so mine's been taxed probably a little bit more.
Oh, there you
recently.
go. Yeah, maybe
You've had
yours
more
needs
time to heal.
some recovery from college drinking.
Yeah, I can't do it like I used to. That's for sure. All right, let's talk through the big bad wolf here, the cost of not having these documents. So the rule of thumb, based on some studies here, is that, and it depends on the value of the estate, but about 3 to 7% of the estate's total value in fees and expenses as a rule of thumb for the cost of probate. So again, how do you avoid probate? Creating a revocable living trust and funding that revocable living trust. So then attorney fees, $250 to $600 an hour. There was a third-party study based in California, which is a kind of a nasty probate state. $1.5 million estate, which just means that was the net worth of the individual when they passed away. If they did not have a trust and they had a will, but it went through probate, you can see $56,000. It was the average statutory probate fee and total expenses. And on top of that, 12 to 24 months to complete that process, which also means that if you do not have a trust, you are going through the probate process. Remember, this is tied up in court until it gets settled. So your beneficiaries aren't even seeing any of the money. Your estate is paying the cost, the legal bills for all of this just to get through probate. And then the people who you want to get your money are not going to get, 100 cents on the dollar because of these different costs. And they're not getting the money for an extra 12 to 24 months, and life can change very quickly.
And not just children, beneficiaries, but sometimes spouses. If someone owns something individually, sometimes the spouse can't get to the money for a year or two. When I see this with California, I think that there should just be a meme on the state of California where it's just California, it's just like a head just shaking like, what's up with California? Seems like they're always on the wrong side of those lists.
Yeah, we'll do a future episode. I know I've been doing deep dives into the state income tax situation. There's a billionaire tax getting proposed there, and just the revenue and the expense, the P&Ls of states are looking very, very different depending on the different states. And California is one that's.
And I love California. I love to visit, but it just is financially not being managed in a very smart way for a long time.